The Queen on the application of associations of independent meat suppliers and another versus the Food Standards Agency.
This case is all about carcass number 77. That was a bull who was best in mart at the auction mart in Darlington, in England. He was bought by an abattoir and passed fit for slaughter by the official veterinarian appointed by the Food Standards Agency. But after slaughter, the official veterinarian decided that the meat was not fit for human consumption, and so it did not acquire the health mark without which it could not be sold as meat. Naturally disappointed that its prize purchase was now virtually worthless, the abattoir sought a second opinion and refused to surrender the carcass. They claimed that the Food Standards Agency had then to use a procedure under Section 9 of the Food Safety Act 1990, under which a justice of the peace can decide whether or not a carcass is fit for human consumption. The Food Standards Agency denied that it had to use that procedure. It maintained that the carcass should be disposed of as an animal byproduct and served a notice for such disposal. The abattoir, along with the Association of Independent Meat Suppliers, brought these proceedings to challenge the Food Standards Agency's view that in cases of dispute, it did not have to use the Food Safety Act procedure to resolve matters. Alternatively, it argued that the UK was required by European Union law to provide some means for challenging the decisions of the official veterinarian in cases like this. The whole matter is governed by a suite of European Union regulations dealing with food safety and related matters. The Food Standards Agency argued that to have a procedure such as that in Section 9 of the Food Safety Act, to challenge the decisions of the official veterinarian as to whether meat was fit for human consumption, was incompatible with the regime laid down in the regulations. The claimants argued not only that the long-standing procedure in Section 9 was compatible with the EU law regime, but also that EU law required there to be some means of appealing against the vet's decisions. Obviously, these questions are important to all abattoirs where meat may be condemned as unfit for human consumption. It doesn't only relate to carcass number 77. The Supreme Court has concluded that the answer to both of these questions is not clear. Accordingly, it is obliged to refer them to the Court of Justice of the European Union for an answer. The exact terms of the reference are as follows. 1. Do regulations EC numbers 854 and 882 preclude a procedure whereby, pursuant to Section 9 of the 1990 Act, a justice of the peace decides on the merits of the case and on the basis of the evidence of experts called by each side whether a carcass fails to comply with food safety requirements? 2. Does Regulation EC number 882 mandate a right of appeal in relation to a decision of an official veterinarian under Article 5.2 of Regulation EC number 854 that the meat of a carcass was unfit for human consumption? And if it does, what approach should be applied in reviewing the merits of the decision taken by the official veterinarian on an appeal in such a case? We will await such answers as we may get with great interest.